Karibuni waheshimiwa washiriki wote kwenye mafunzo ya Publication of Court Decisions, Laws and Online Legal Research ambayo yanatarajiwa yataanza kuanzia saa 8 kamili mchana huu, na kwa hiyo tunawakaribisha washiriki wote, na tafadhali tunaomba tafadhali tu mute mics zetu wakati wote mpaka pale ambapo tutahitajika kuzungumza kwa maana ya kuchangia au kuuliza swali wakati utakapofika wa discussion kwa maana ya maswali na majibu. Kama ratiba yetu ambayo tumeendelea kuishare inavyoonekana, wawezeshaji watakuwa Mheshimiwa Jaji wa Rufani Mheshimiwa Mgeekwa, tutakuwa kwa Jaji wa Mahakama Kuu Mheshimiwa Said Kalunde, tutakuwa na Mheshimiwa Aisha Sinda, Jaji wa Mahakama Kuu ya Tanzania, lakini pia Mheshimiwa Kifungu Mrisho Kariho ambaye ni naibu msajili wa Mahakama Kuu ya Tanzania, lakini pia ni mkurugenzi wa huduma za maktaba Mahakama ya Tanzania, na mheshimiwa ambaye atatufungulia mafunzo siku ya leo ni Mheshimiwa Rutamu K. Philip, Jaji wa Mahakama Kuu ya Tanzania kanda ya Dar es Salaam. Kwa hiyo tunawakaribisha sana washiriki wetu, lakini tafadhali kama wakati mada zinapoendelea kuwezeshwa utakuwa na swali utakapofika muda wa saa 8 kamili tukapoanza opening session yetu, na baadaye mada kuwezeshwa. Kama utakuwa na swali lolote, tunakuomba uweze kuliandika mahali au utumie chat box yetu ambayo ipo ndani ya platform hii. Kwa hivyo tafadhali, kama utakuwa na swali unaweza ukalitunza mpaka pale ambapo kutakuwa na nafasi ya maswali na majibu. Utaweza kutumia kama umeliandika katika chat box, basi wawezeshaji wetu tutawasomea na wao kuweza kuyajibu maswali hayo, lakini pia unaweza raise your hand kwa kutumia icon ambayo inaonekana kwenye platform, mbele ya platform yako, ambayo inakuruhusu kuweza kunyoosha mkono ili uweze kuuliza au kuchangia kile ambacho unacho. Kwa ajili pia ya utulivu wa platform yetu na usikivu mzuri zaidi na umakini, tutaomba tuendelee kuzima kamera zetu na kuendelea kuweka off, isipokuwa tukua wawezeshaji na wale ambao watakuwa wana share slides. Kwa upande wa wawezeshaji, sisi wengine tutaomba tuweke pia kamera zetu off, kwa sababu pia inaongeza nguvu ya connectivity wakati tunapoendelea kufuatilia mafunzo haya. Kama kutakuwa na swali lolote au kuna hoja yoyote, tafadhali usisite kutumia chat box hapo chini, na unaweza pia sio kuuliza swali tu, unaweza pia hata ukachangia uzoefu wako kuhusiana na eneo ambalo linawezeshwa. Wenzetu wanaendelea kujiunga na mafunzo bado hayajaanza, yataanza saa 8 kamili kama ambavyo ratiba yetu inaonyesha, ambapo atakaribishwa Mheshimiwa Jaji Utamu Kasuka Philip, Jaji wa Mahakama Kuu ya Tanzania kanda ya Dar es Salaam, kwa ajili ya kutoa neno la ufunguzi, na baada ya hapo zitaanza mada za wawezeshaji wetu mbalimbali ambao wataeleza kuhusiana na historical background of online publication of court decisions, laws and online legal research. Lakini for easy of follow up, I am going to share my screen so that we can see the topics that are going to be presented in this area this afternoon. And please kindly feel free to write any comment. If you have any question, you can put it in the chat box, or during questions and answers, please be free again to raise your hand, and then we allow you to unmute yourself and ask your question or comment if you have any. So please welcome you all in this very important training insofar as the access of justice is concerned. And let's be free to ask and comment, as I've said recently. So yes, let me now share my my screen. Ziada Mkwazo, I think you can see the flyer that I'm sharing. Is it not so? Ziada, may you kindly unmute yourself and speak if at all I'm heard on the other side.
Sorry, what did you say, Kaswaga?
Just asked, do you see what I'm sharing in my screen now?
Yes, yes, I see it very clearly.
Thank you very much. I'm glad that I'm heard on the other side. I'm not speaking to myself. Yes, as I said earlier, dear participants, we are about to start saa nane kamili, and the language that will be adopted is English throughout our training. And please, if you have a question you wish to ask in Swahili, just be free to do so, because we will be more English and then we'll have a little Swahili. So kindly be free to use any language to ask your question. Don't be tied by the fact that we'll be using English. You may be free to use Swahili as well, and your questions will be answered accordingly. Now, as I said earlier, we are kindly asking us to put off our cameras so that we can have smooth conducting of this training, because we can have somehow not very suitable backgrounds on your side. So please kindly do, if you choose, you can put a background on your side, or if need be, and which we actually insist, put off or turn off your camera ili kusiwe na mwingiliano wa yale ambayo yanaendelea nyuma ya kamera yako. Na kwa sababu pia yatakuwa yana pop up mara nyingi kama utakuwa ume switch on your camera na una activities unaendelea nazo, it will be coming on kwa participants wengine. So we are kindly asking that we put off our cameras and we switch them off, please, so that tunakuwa na conducive environment for the training. Tafadhali, we're insisting, unless you are asking a question, you can then switch it on, or you can unmute yourself and speak. But for the time being, we are kindly asking that we put off all our cameras kwa ajili ya utulivu. So kindly, again, we are asking ourselves, and I am kindly asking us to mute ourselves and put off our cameras, and again to just wait for just a few minutes before we start our program for today, because we have at least 18 minutes before we begin our session for today. Kwa hivyo tunawakaribisha sana all participants. Na again, as I said earlier, and I'm insisting because others have been joining, kama una swali wakati presentations zinaendelea, please use the chat box to put your questions, and the moderators will be reading your questions, na wawezeshaji wetu watakuwa wanayajibu accordingly. And again, as I said, this is experience sharing. Please, we are kindly advised to also share experience apart from asking questions. Kwa hiyo asanteni sana na karibuni tena kwa mara nyingine kwenye this platform kwa ajili ya training yetu ya publication of court decisions, laws and online legal research. I understand that we are mixed here with advocates and others from the legal fraternity, and all the justice sector stakeholders are joining us, including I see some students. So please, we are kindly asked to observe our culture, the culture of the legal fraternity. And so please, we'll continue to insist you to put off our cameras and switch them off so that we have a conducive environment. We are not interrupted by any way or interrupted by the backgrounds on your sides there. Kwa hiyo karibuni sana washiriki wote, na sasa we are left with 16 minutes before we start our program. And as we are approaching towards the commencement of the training, we will keep ourselves reminded of some few things to take care of or to consider while we are participating in this very vital training on publication of court decisions, laws, and online legal research. Kwa hivyo, karibuni sana na tunaendelea kuwakaribisha wengine. We are meeting them as they are joining. Asante. Banana Feroz Kalema, I think you're not intending to be showing your background. So if you don't mind, please, we are kindly asking that you put off your camera. Thank you. Asanteni sana ndugu washiriki, na saa 8 kamili tutaanza mafunzo yetu. Bado tunaendelea kusisitiza kwa ajili ya utulivu. Kwa sasa tutaomba wale ambao ni wawezeshaji pamoja na waheshimiwa wanaofunga na kufungua mafunzo wanaweza kuendelea kuweka uh, kamera on na pia kuzungumza, lakini the rest tunaendelea kuwaomba na kuwasihi kwamba tuweke off kamera zetu, lakini vile vile tuweze mute ourselves, isipokuwa tu wawezeshaji na waheshimiwa ambao wanafungua mafunzo pamoja na kufunga kama nilivyotangulia kusema. Asanteni sana na karibuni sana, na tunaendelea kuwaomba washiriki tuendelee mute mic zetu kwa ajili ya utulivu, lakini pia wakati utakapofika wa kuzungumza, basi tutaruhusiwa kuweza unmute ourselves na kuweza kuuliza swali au kuchangia kwa kuzingatia mada ambayo iko leo katika majadiliano haya. Asante sana.
Hata sijafaidika.
Arnold, tafadhali, tumejaribu kumute mara kadhaa, una unmute na kuzungumza kwenye mfumo unaleta hali ya kelele. Kwa hivyo tafadhali tunakusihi uweze kuendelea kumute mic yako ili mazungumzo unayoendelea nayo yasiweze kusikika katika platform hii. Asante sana. Mheshimiwa Neema Turuka, kama unaweza kuweka off kamera yako tafadhali, tunakuomba uweze kufanya hivyo, na wakati tunapoelekea kwenye kuanza ufunguzi wa mafunzo yetu ya siku ya leo. Kama alivyosema pale awali, tunao waheshimiwa majaji mahakama ya rufani. Tunaye Mheshimiwa Agnes Mgeyekwa, jaji wa mahakama ya rufani. Tunao waheshimiwa majaji wa mahakama kuu kiongozwa na Mheshimiwa Jaji Butamo Philip ambaye ndio anatufungulia mafunzo yetu, mgeni rasmi wa mafunzo haya ya siku ya leo. Tunao mahakimu, naibu wasajili mbalimbali, lakini vile vile tunao wadau wengine wa sekta ya sheria ambao wameungana nasi siku ya leo kama mawakili, lakini na wadau wengine kwenye sekta ya sheria na utoaji haki. Kwa hiyo tunawakaribisheni sana waheshimiwa wote na ndugu washiriki ambao mmejiunga nasi siku hii ya leo, na kwa kuwa sasa ni saa 8 kamili na kwa mujibu wa ratiba yetu itakiwa tuanze na kufungua bila kuchukua muda wenu mrefu, na kwa kuwa naona Mheshimiwa Jaji Butamo Philip yupo pamoja nasi, nimekwisha kujiunga. Naomba sasa niweze kukaribisha Mheshimiwa Jaji kwa ajili ya ufunguzi wa mafunzo yetu ya siku ya leo. Karibu sana Mheshimiwa Jaji.
Asante. I hope unasikika.
Unasikika vizuri Mheshimiwa Jaji, karibu.
Asante. Honorable Dr. Paul Kiwelu, Justice of Appeal and the Principal, Institute of Judicial Administration, Lushoto. Honorable Red Justice Agnes Mgeyekwa, Justice of Appeal and Facilitator of this training. Honorable Judge John Kayoza, Judge in Charge, High Court of Tanzania, Manyara. Honorable Judges in Attendance. Honorable facilitators in this training. Honorable Resident Magistrates of various ranks in attendance. Members of the online training secretariat and liaison officers. Moderators of this training, ladies and gentlemen, good afternoon. Distinguished participants, first and foremost, I would like to give thanks to Almighty God for the gift of life, health, and for making it possible for us to gather visually for this important training. It is through His grace and that we continue to advance our knowledge and service to the judiciary and the people of Tanzania. Distinguished participants, I extend my deep appreciation to the judiciary leadership under Honorable Professor Ibrahim H. Juma, the Chief Justice, and other esteemed leaders for endorsing this training and ensuring we continue to build our capacity to meet the demands of the legal profession in this digital age. Dear distinguished participants, I would like also to sincerely thank all our facilitators for dedicating their time to share their vast experience with us. Honorable Mgeyekwa, Honorable Kalunde, Honorable Sinda, Professor Majamba, and Honorable Kifungo Mrisho, your contribution is invaluable and so precious that we cannot assign a price to it. And we are truly privileged to have you guide us through this critical discussion. Distinguished participants, the importance of this training cannot be overstated. The session on online legal research tools and resources will introduce participants to platforms beyond Tanzania, providing essential knowledge on how to effectively use these tools in our daily works. Additionally, guidance on assessing the credibility and reliability of online legal resources will be covered, and emphasizing the importance of relying on trustworthy platforms such as Tanzania, Westlaw, and LexisNexis for the accurate research will also be covered in this discussion. The training will also delve into the evolution of court decisions and law publication in Tanzania, offering insights into the historical context and its relevance to legal education and the broader dissemination of legal information. Distinguished participants, lastly, I would like to say that The attention will be given to the challenges in the judicial publications, addressing key issues such as data security, accuracy, and maintaining the integrity of court records, all of which are critical for fostering trust in our legal system. This holistic approach will ensure that we are better equipped to navigate the evolving landscape of legal research and publication while upholding the principles of justice. This training is incredibly relevant to our shared goal of enhancing access to justice by improving our ability to research, publish, and access legal information. We will strengthen the judiciary's role in ensuring that justice is not only done, but is seen to be done. Efficient access to accurate and reliable legal resources is a key element in achieving fairness and transparency in our courts. Distinguished participants, I call upon all of us to actively participate in this training, ask questions, share experiences, and engage with the facilitators. This is a rare opportunity to learn from the experts in the field and to strengthen our knowledge, which will in turn enhance our capacity to deliver justice. Distinguished participants, in conclusion, I once again extend my deepest gratitude to our facilitators, our leadership, and each one of us for making time to be part of this important session. Let us use this opportunity to grow and to ensure that we are better equipped to fulfill our roles in the judiciary. Let us have a productive and insightful session. Thank you very much for your kind attention, and I wish you all the best during the discussion throughout this session. Thank you.
Many thanks, Your Ladyship, Mheshimiwa David Butamo Philip, for the very insightful opening remarks that you have given. And we thank you for taking your time. I know you have a very busy schedule, but you have taken time to accept and open this training. Now, going to the agenda, I would like to take this opportunity to welcome Honorable Kifungu Mrisho Kariho, who is the Deputy Registrar and the Director of the Library Services in the Judiciary of Tanzania, so that he may start with the first topic, which is the historical background of online publication of court decisions, laws, and online legal research. Karibu sana Mheshimiwa Kifungu Mrisho kwa ajili ya mada hiyo kwanza.
Thank you very much, Honorable Kaswaga. My name is Kifungu Mrisho, a Deputy Registrar, as you said, and I'm very thankful. It's very thankful from the Honorable Philip from her opening remarks, and I really appreciate because the opening remarks illustrated more on how we are in the digital age and the publication of court decisions and laws is concerned. My duty is simple. It's just to come up with a background of the publication of laws and law reports and court decisions. As you have said, Honorable Kaswaga, it is an historical background. And this historical background came from when we were under the colonization and under the German colonial rule up to British colonial rule. And it is since in 1922 is where we started to have law reports. And the law reports are very important because those law reports serves the importance of guidance and what the law is, and they provide raw materials to facilitate the application of laws to real situations and real people in every day. And the brief history of law reporting in Tanzania starts when we were in the British colonial rule, and it was in 1189 when the England British system started to come up with the law reports, and it was just on individual basis. Then in 1922, and especially when we started with the High Court of Tanganyika, we had the law reports of Tanganyika, which was from 1922 up to 1952. That was the first volume. And then we came up with the second volume, which was 1953 to 1957. And then the period between 1958 up to 1966, it's too bad there was no NLO report, but with the inclusion of the University of, with the Faculty of Law of the University of Dar es Salaam, in 1967, we had the High Court Digest from 1967 up to 1972. And then we had as well the law reports of Tanzania from 1973. Report of Tanzania, and the law report of Tanzania, we had law reports of 1980 up to, we have the law reports of 1980 up to 2006, then 2007 up to 22. These law reports are in existence, and we have them in soft copies. We are now creating the electronic library from the ECAS management system, which is going to be integrated with the ECAS management system. And eternally, and these law reports, we can just find them physical in a hard form, but we have them as well in the soft form. And then these law reports in the soft form are going to be available this year, because we are going to develop the electronic library, and then the link will be inserted there for every judicial officer to access them. And we have the historical background as well of having a court decision. For example, in the article of the Constitution, Article 18, it provides for the availability of information. And then we as judiciary were supposed to give out information freely because of the Constitution. But we have as well the Access to Information Act under Section 4 and Section 5. It says that each and every information holder is supposed to share the information to the people or the public who are in need with those information. And then in 1993, there was a circular of the Chief Justice, which indicated that decisions are not supposed to be are supposed to be delivered, and they are not supposed to be delivered on notice, because there was a tendency of judicial officer not to give out decision or to deliver decisions, and it was like there was orders that decisions are supposed to be delivered on notice. And then this circular came out and say, no, decisions are you are supposed to say a certain date that you're going to deliver decision. And then in 2002, we had the Judiciary Clients Charter, which says that there was a problem of delivery of decisions and obtainance of decisions to the public. And then it addresses that every judicial officer is supposed to come up with the decisions and give out decisions for people who are supposed to seek for other rights. And then in 2006, under the circular number 1 of the Chief Justice, it came out indicating that decisions are supposed to be delivered in 21 days after the hearing. And it just indicated some provisions of the law, which shows hearing is supposed to be conducted within 90 days, especially when it comes to civil procedure, Section 28, criminal procedure is Section 11 is 311, and the Court of Appeal rules under Rule 34. And thereafter, we had we had court fee rules, the circular we had the circular number 1 for court fees, which says decisions are supposed to be available to parties with no costs. And then thereafter, we had GN number, 187, GN number 247 of 2018, which revoking the GN number 187 of 2015. And these GNs were just to cement that decisions are supposed to be available freely. And then we had direction of the Chief Justice, direction number 2 of 2018, which says all decisions which are delivered when it comes to an issue of a charge, especially when it's an issue of a lab, or there is an issue of adoption, we're supposed to hide the identities. And we are not far from the Judicial Administration Act as well, which came up with the Code of Conduct for Judicial Officers, which is GN number 101 of 2020. It gives out on how we are supposed to be responsible as judicial officers to come up with decisions on time. And then it shows on how this can just be a disciplinary measure when you fail to abide with coming up with the decisions on time. And under Section 35, you may be disciplinary. You may get disciplinary action from the Judicial Administration Act. And then in 2023, which is just last year, we had circular number 1 of Chief Justice, of which it's amended circular number 1 of 2016. This circular of 2016 indicated that parties are supposed to get their delivered judgments within 21 days. But this circular number 1 of 2023 came up and said and indicated that because we are in the journey of technology and every judicial officer has a laptop and we are typing on our own, it is now time for judicial officer not to deliver a judgment or a decision if that decision is not ready. So you deliver it and then it's supposed to be given to parties on the same day or uploaded to officials' platform of the judiciary. And then lastly, this year, by the GN number 188 of 2024, which amended the Court of Appeal rules. The Court of Appeal rules this year was amended under Rule 34 to give room to all decisions which are published on the platform to be recognized as list of authorities when it comes to any legal opinion or any judgment. So reference at the moment can just be made from our platform. So this is the historical background of where we was and where we are, but mostly because today we are talking more about the publication of court decisions and laws, especially principal and subsidiary registration. We may mostly talk about Tansley, which started in 2010, and then it has so many decisions from 2019 up to today. And this time we have started to digitize decisions from 1970s up to 2018. So this is the background we have now. And thank you so much for your attention. Thank you.
Many thanks, Mheshimiwa Kifungo Mrisho, for the very insightful and very interesting historical background of the online publication of court decisions, laws, and online legal research. I hope at a particular moment in time we'll be able to get the presentations and we'll share with the participants when they are ready. For now, we are within time, I can say, and thank you very much again, Honorable Kifungu, for keeping time, as well as what did Justice Butamo Kasuka when opening the session. Now we are going to the second topic, which is the evolution and impact of court decisions and laws publication in Tanzania, historical overview, legal education, and collaborative efforts. And this will be delivered by Professor Hamudi Majamba. We understand that Professor Majamba is a teacher and a lecturer for most of us. And for now, let us know that he's a professor of law from the University of Dar es Salaam, Faculty of Law, School of Law, formerly the Faculty of Law, and editor-in-chief of Tanzania Law Report Board. And now, without taking much of your time, let me welcome Professor Hamudi Majamba for presenting his topic. Karibu sana, Professor Majamba.
Thank you, Honorable Kaswaga, Honorable Lady Justice Agnes Ngeyekwa, the Honorable Butamo Kasuka Philip. I joined you about 1 minute late because of online problems at the University of Dar es Salaam. But now I'm glad I'm there. So my topic will not reiterate what Honorable Kario has said. I'll focus very, very briefly and maybe highlight on the evolution of court decisions in the context of reporting. Today's topic also requires us to discuss the laws and online legal research. So as pointed out by Honorable Kim Kifungu, the idea of law reporting is traced to, in the common law jurisdictions, is traced to the UK, in England. And for the benefit of members, participants, and all of you, there is a paper that was published, has been published in 2002, and I'll share this with you. So what I'll be highlighting very briefly are the extracts from that to slightly feed on Mr. Kario's presentation, but also to bring about one important component that relates to one law reporting, and this is about access to justice. So access to justice requires access to court records. And that link also goes in tandem or hand in hand with the idea of what we all know about the doctrine of precedent, which requires certainly that you must have law reports. So as pointed out earlier by Mr. Kario, the earliest law reports in England were referred to as yearbooks. And these traced the origin in 1275. And these ones comprised of notes of cases, and these contained accounts of only arguments by counsel, and they were written by students and junior members of the bar. In terms of education, when you have the link to education, you realize now that there is some element of education, that is students who learned law, they attended the courts, and they took notes to study law through yearbooks. And then later on, between 1535 and 1865, the access to records was also not allowed, was only restricted to lawyers acting on behalf of the crown. So it's only lawyers who went to court and recorded, published these court records. The yearbooks, I'm not sure whether we have not been intercepted, Chairman, by people. Do we have our internal security people in terms of, or rather these are participants. So I will just proceed. So you have, there was restricted circulation. And as a consequence of that, the restricted circulation, there emerged private law reporting. Private law reporting, and most of the private reports were referred to by the name of the reporter, and they had the authority. And in some cases, some judges were also involved. Now, modern law reports, in terms of that, this replaced the yearbooks, and there was a need. There was a need because of a number of reasons. The quality became poor. There were too many private law reports, and there was a need to regulate reporting. The reports were also expensive. So there was a formation, formal recognition of the need to regulate law reporting commenced in 1867 members by the creation of the Council of Law Reporting in England in 1865, and then it was incorporated as a company in 1867. This council also had its modus operandi stated in the memorandum that established it. You'll read this later. It was also focused, among other things, it was charged with identifying the kind of reports, the kind of judgments to report. Not all judgments were to be reported. Some reports could be in there. Therefore, after a while, you find now the emergence of the appeal cases in terms of that, the chancery divisions, you have volumes of the Queen's Bench, and also there was also a specific reporting system for cases from the family law division of the High Court in England. I will not go into selection of that, but what now, if you fast track, that was the procedure. Later on, because of technology, and that's why I'm moving to our topic today, in technology, there was the digitization of law reporting. It commenced in England in the 1990s. Digitization and the internet. And here you find that there was the ELR, electronic law reports, consisting of a set of CD-ROMs then, and containing the entire output of the law reports then. And then there were also discs, which included the weekly law reports, and also industrial cases. Because of the issues of labor, the cases of industrial were reported separately. This became the main highlight. And in 2011, the reports were launched, and it had its own platform in England. And since then, it's been reporting online. However, the hard copies were not withdrawn, so they still exist. So you have both online and also hard copies of those judgments. That is a historical perspective. Very briefly, like I said earlier on, I'll share with the organizers the report that I extract this from. Is very, very useful, and there are many other references in this report that you could also refer to. In terms of the historical overview in Tanzania, this has been lucidly elucidated by Honorable Ifungu, and I will not belabor much, just to emphasize on a few things. There was also, throughout the process, from 1967 to 1972, that's when you find the concept of education. I'm supposed to discuss that. Education in terms of, you see the Faculty of Law of the University of Dar es Salaam assisting the judiciary. There was some understanding, legal understanding, that the faculty would help through a committee which provided digest of the cases that were from the High Court, just the High Court. What about appeal cases were not touched. So the input in terms of education was from the Faculty of Law, and then it was the only faculty teaching law in East and Central Africa. I think the history of that you all know. The main editors were from the faculty, but there were also representatives from the judiciary, way back in 1967 and 72. And that part explains my role when I come in. The Faculty of Law from 1973 to 1979, it continued. And then in 1980, the administration of reporting moved from the Faculty of Law to the judiciary. And the first chair was a judge, and this was no other than Honorable Barnabas Albert Samata, former justice. And that did not necessarily leave out the role of education in the publication of law reports. And that also included legal research. The idea here was that legal researchers or people researching on law had the ability to trace a number of things in respect of students of the law, in terms of cases from other jurisdictions, And the faculty then, remember, there was no internet. There was no internet. There were no, we were relying on, when I say we, I wasn't there, but the faculty was relying on contacts from colleagues from other jurisdictions. Some of the professors who were taught here at the University of Dar es Salaam went to other universities. Almost all members of East and Central Africa who were lawyers, who were in different judiciaries and legal bodies within Africa and beyond, were a product of the Faculty of Law. And therefore it was easy to change ideas, also to change judgments in terms of that. And even the reporting then in those countries, there was that sharing. Maybe a judge delivers a judgment, a colleague from who knows somebody there would send it to the Faculty of Law, it would be psycho-styled and shared among people, and eventually to the judiciary. And if you realize in some of the judgments that during the times of the human rights crusade, so to speak, within the judiciary, there was a lot of referencing by articles, by prominent legal scholars from the University of Dar es Salaam, who had written widely and published widely on that. So in terms of the relevance, Chair, education, legal education in Tanzania and beyond, universities started that, and across the spectrum, we have programs from certificate in law since time immemorial, and this made reference to they needed law reports. Now we have a program called BALE, we have the LLB, etc., and the history of legal education is predominantly based on that. In terms of collaborative efforts in Tanzania and beyond, like I said earlier on, we are still in touch, and the judiciary is still in touch, and it's important to continue this collaboration, because development of principles and doctrines of law, equity, and access to justice, and the rule of law are diverse. They've been developed by different courts in different countries. If these court cases are not reported, they will not be accessible. But the emphasis here, again, I should remind participants in our discussions, access to official public records. Our history tells us there was, at one point in time, unofficial reporting, which caused a lot of trouble. In line with that, I should also point out that although you have the judiciary on board in terms of law reporting, we should also not forget that there are other reports that are still in Tanzania published by entities other than the judiciary, maybe under the control of the judiciary. And here I have in mind, some of you are aware of this, we have tax law reports, you have reports at one point in time, our bar association, the Tanganyika Law Society, used to produce reports, and they're there. That one I remember, it was by virtue of some delegation through the Chief Justice. And you also have law reports from the labor courts. These ones are also reported. And along all these lines, there's been assistance from education. Faculty of Law now, and also other faculties now, have contributed significantly to developments of these reports. So that should be not lost off in terms of education. Remember, when it started, initially, it was reporting was done for legal purposes. People are there to study law. So that should be continued. In terms of collaboration, I have in mind here, and development and beyond, you have in mind here associations of judges, you have associations of judges, magistrates, bar associations, regional blocks, that means EAC, SADC, academic institutions, UN agencies, development partners, government, parliament, and the private sector that is involved in ICT. In conclusion, before I conclude, I would like to point out one thing in terms of international bodies. And I thought this is the most appropriate time to say it. When you're looking for laws, here I'm talking about publication of laws. If you all remember, at one point in time, there was some cry from a cross-section of Tanzanians inquiring on the Articles of the Union. Articles of the Union. This is a law. Okay, there were difficulties in accessing it, but ultimately, one Dr. Asha Rose Migiro, the then Deputy Secretary General of the United Nations, between 2007 and 2012, made this accessible to government from the archives of the UN. This was quite a landmark, and I'm saying this because access to justice, access to information, access to laws, publication of laws, publication of et cetera, that is common. In terms of publication of laws, we are all aware of the Interpretation of Laws Act, CAP 1, which provides for making laws relevant. The standing orders Parliament are also relevant, but also the Constitution of the United Republic of Tanzania in terms of publication of laws. So the history that could be also read in that context. Conclusions. The conclusions I draw, Chair, for discussions maybe are the following. Around 5. Number 1, digitization has come very timely and has helped to access legal documents and also legislation. This will foster easy access and delivery of justice in Tanzania. Continued legal education is critical, but this should target local communities in terms of education, in terms of facilitation, and the use of simple, clear, and very friendly language. The infrastructure is required. We are aware it is costly. It needs funding, it needs human resources and stakeholders' engagement. And again, collaborative efforts must be made. Now, the challenges will continue and they still exist. These will be discussed by colleagues in this session. And with those remarks here, I wish to submit for other deliberations. Thank you very much for your attention.
Many thanks, Professor, for your very insightful presentation. And I must say, it was very interesting. And we cannot say thank you enough for finding time from your very busy schedule, but you have joined us in this training. Asante sana. And now let me welcome Honorable Lady Justice Agnes Mgeyekwa to give her topic on comprehensive overview of online legal research tools, resources, and popular platforms beyond Tanzania. And before her ladyship starts presenting, I would like to remind us, please, to mute our microphones if you're not speaking, put off our cameras for the smooth environment of this training. And again, be free to put, if you have any question, put it in the chat box, or you may opt, if it pleases you, to please raise up your hand at the end of this training so that you can be allowed to speak. Kwa hiyo karibuni sana, and please be free to either use the chat box or ask a question. Please now let me welcome Honorable Lady Justice Agnes Mgeyekwa for the presentation. Karibu sana Mheshimiwa Jaji. Mheshimiwa Jaji Mgeyekwa, karibu sana. Nafikiri huja unmute your microphone. Kwa hiyo nakuomba Mheshimiwa Jaji uweze karibu sana Mheshimiwa Jaji, naona sasa ume unmute.
Okay, thank you. Honorable Butamo Phillips, guest of honor, honorable judges, Justice Court of Appeal and judges of High Court, honorable deputy registrars and resident magistrates who are following our presentations today, and other participants. I'll take you through the third topic of today, which is in regard to overview of online legal research tools, resources, and popular platform beyond Tanzania. In my presentation, I will highlight the following. I will talk about online legal research, and then secondly, how legal research websites enhance access to justice, and lastly, I will highlight on popular platform beyond Tanzania. Now, beginning with online legal research, in general, it refers to the process of using digital tools and database in order to find legal information such as case law, regulations, and legal commentary. This research is typically conducted through specialized platforms like Tanzania Legal Information Institution, common known as Tanzli, but we have also other links like African Lee and other legal research websites, which are very common to us, like the one with from Kenya, Kenyan's Law, and the other one from South African. I think all of you are familiar with those other legal research websites. Now, with regard to Tanzli legal research website, all of you are aware that it carries a variety of Tanzania legal materials, including case law from the courts of records. We have also legislation and judicial of Tanzania documents, guidelines, and government gazettes. Therefore, online legal research has become an essential part of legal practice, offering access to a wide collection of resources and tools for professionals and other researchers. When we talk about legal tools and resources, we normally refer to various platforms and materials that assist individuals and professionals in understanding and applying the law. And some of them include research database. This is a platform for finding case law, regulations, and the same as I mentioned earlier, we have Tanzli, Kenya law, Nigerian law, African law, Malawi law, just to mention a few. But also, we have legal tools and resources in forms of forms, for example, contract forms and will forms. We have also case management software. These are tools that help legal professionals in communicating with their clients. Apart from that, we have also other legal tools and resources, which include online legal services. This is another legal tools. On online legal services platform, we are connected with individuals, whereas we can give them legal aid or advice, and also our clients have an opportunity to have legal representations from our counsels. And in Tanzania, a common link is the one which is well known to us. It is eWakili. But also there is another link, it's called AVO. This is based in the US. All of them are online legal services, legal services. As mentioned earlier, now I'll move to another part of my presentation, which is how legal research websites enhance access to justice. On this part, we are aware that when we are doing legal research, in one way or another, we are enhancing access to justice in many ways. And I'll mention, I'll just pinpoint a few. One of them is legal research website, which enhance access to justice by providing extensive access to legal information, allowing individuals to find relevant laws and cases without needing a lawyer or without using money to hire a lawyer. And another one is many legal research tools are affordable. They are easily affordable and freely accessible. In other words, there is no need to subscribe or to pay any money. What you need is only to have an internet connection. And also, legal research websites are user-friendly, making it easier for individuals to understand legal concepts and find the information they need. Another one, legal research website enhance access to justice by educating individuals. It helps users to stay informed about changes that may affect their cases. And individuals are empowered to represent themselves in legal matters after accessing information from the website. Apart from that, also online resources often provide the latest information. In other way, individuals can access and get easily latest information For example, when you visit Tanzli website, it is easy to find recent legislation and recent judgments of the High Court and the Court of Appeal. In other words, these legal research websites play a crucial role in promoting equity and fairness within the legal system. Now, beyond Tanzli, there are other platforms and resources available for comprehensive legal research. I'm saying so because we are so much familiar with Tanzli, but there are other resources outside Africa which can be accessed by us, and the same as follows. And some of them, before I mention them, some of them are open, I mean accessible to all users, freely in charge, and other websites are only for respective jurisdictions. And always we need to try, or urge you to try authentic legal research websites or reputable resources, and avoid the legal research websites which may not provide reliable information. So now I'm going to mention the other platforms. As mentioned earlier, we have Tanzli, African Lee, Kenya Law, Gali, Laribianza, Malawi, this is Malawi Lee, and many other African legal information institutions listed in Tanzli website. Now, apart from those ones, there are other websites such as Eurolex. This is an European Union legal website, and unfortunately, it provides legal research tools and resources specific for European Union members countries only. So in other way, we cannot access them. And there's another legal research website is Australia, which means Australians Legal Information Institute. This provides free access to legal information from Australia and the Pacific region only. Another one, which was also mentioned by the guest of Hannah, is Westlaw. This is primarily used in the United States. However, it also has versions tailored for other countries, including the UK and Canada. That means African countries, unfortunately, the one in African countries cannot access this website. And this Westlaw, it's a leading legal research platform providing access to an extensive database of legal resource, including case law, regulation, and secondary sources. Now, apart from that one, there is also another one well-known website. It's called LexisNexis. LexisNexis. This is another major player in legal research based in the United States and operates in other global regions. That means it is easy for us to log in and have an opportunity to access cases and other documents. Apart from that, there is also a common journal, which is called Journal Storage. This is a digital library that provides access to thousands of academic journals, books, and primary sources across various disciplines. Now, from what I've said, in Tanzania, apart from Tanzli, all of you are familiar that we have Tanzania Law Reports, and also we have e-library. When I say e-library, I mean judicial e-library, on which all of the same are very easy to access, but right now or currently, the same cannot be accessed online. So maybe in the future, it will be easy for us to access Tanzania Law Report online and even the e-library. Now, when I'm ending, I want to make it clear that all the legal websites which I've just mentioned provides easy access to laws, helping individuals and professionals to understand their rights and obligations. Also, they help to create public awareness by educating the public about legal process, rights, and current amendments of the law. And overall, legal websites contribute significantly to transparency, education, and access to justice worldwide. So having said so, now allow me to end my presentation. Thank you for listening.
Asante sana Mheshimiwa Jaji Honorable Justice Agnes Mgeko for the presentation. Now I welcome Honorable Saidi Kalunde, Judge of the High Court of Tanzania, Iringa, for giving his presentation on assessing credibility, digital transition, and emerging trends in online legal research platforms and technological innovations. Karibu sana Mheshimiwa Jaji Kalunde.
Hello, Mr. Kaswaga. I don't know if I can be properly heard by the panel.
Yes, we can hear you, my lord.
Okay, let me try to share some slides of what I intended to share so that we can probably follow. These are just mere talking notes. Mr. Kaswaga, I hope you can see, so I can confirm that the audience can also see something.
Yeah, yes, my lord, you have shared the screen.
Okay, good. And okay, so and then take off the. Is it still viewable? Because I can't.
Yes, it is, my lord.
Okay. Thank you for this invitation. Thank again for the members who are attending this important session where we are sharing some knowledge on publication of court decisions, laws, and how actually we can improve our legal research. I also wish to thank my initial speakers, including the guest of honor who blessed this auspicious occasion. Mine will be to look at a few things on how to assess the credibility of some of these resources that we've been referred. But then I'll briefly look at the emerging trends that are relevant in legal research. Briefly, this topic, the first one and the second one, probably are longer than what we could afford in the next 15 minutes. But I hope the discussions that will follow will also raise some key questions that I think members have. So basically, in this session, we'll look at a bit briefly. The sources of legal research have been covered by Honorable Kifungu, Professor Majamba, as well as Justice of Appeal, Madam Mgeyekwa. So I've checked that out. Then I will look at the key aspects of assessing credibility of some of these sources, especially in the context of online environment. I will also look at the key precautions that we need to be taking in terms of contextualizing the presentation. We'll also look at the emerging trends and technologies, but basically here we'll look at two components that we shall observe soon. Of course, this is because of the timelines, and then we will wrap up our 15-minute session. So, of course, after the discussions that have come from Madam Lord Justice, or no, Madam Justice Mgeyekwa, Justice of Appeal, you will note that a lot have been referred about online sources. That is, these are sources that are foreign. Some of them are local, some of them are foreign, some of them are from different jurisdictions and different sources with different agendas. So one would ask, in terms of why would the organizer of this session would bring in an issue about assessing the credibility. Remember here, our opening speech and what had been discussed here is centered around access to justice and ensuring that we have a better and advanced legal system that promotes rule of law and essentially access to justice. So why should we be worried about sources? We should be worried about credibility of the online sources because depending on where you're working, whether you are a lawyer, you are a social organization, you are an entrepreneur, you are just a society that is interested in promoting probably rule of law, or you are just a normal mwananchi. In law, legal accuracy is very important. Very important is that access to justice is based upon legal accuracy. If you're citing an authority, it should be a correct authority. Similarly, the source reliability is very important because if you're going to a judge, if you're going to a magistrate, if you're convincing your sponsors, if you're convincing your client, the reliability of the source of your law, the source of your material is very key, and they would inform and they will determine whether this information should be relied or not. But then there are practical implications if you cite a wrong source. So we should also consider that. So it is important to assess the credibility, and I'm sorry the title there is a bit misleading, is I instead of E. But we also have an issue of bias and agenda. I mean, you can cite a particular source which has a biased agenda in relation to a particular topic. So you should be very careful whether that source has a biased agenda or has bias or has an agenda against a particular topic. So you have to know, you have to understand whether the source that I'm citing has a bias probably on human rights, has a bias probably on a particular area of the law. So you need to know that. But then when you're making a citation, there are also some rights that you could face. I mean, if you face an unreliable source or a wrong citation of a book, you probably have litigation follow after that. So it is also important as a lawyer, as a mwananchi, as a society, as an organization to make sure that you protect yourself against your rights as against the third parties. But as for lawyers, this one is specific, and even for judicial officers, here I mean magistrates and judges as well, legal officers and whoever is involved, we have ethical considerations. Citing a wrong source or citing from a wrong source could also have ethical and practically at sometimes legal implications. So this is why it is important to also look at the credibility when you're looking at the source of your reference in terms of online sources. But then key here is what are the key considerations. So since the source is an issue, consider what is your source of authority. I mean, what is your source of authority? Does that authority have probably certain credentials? Very important to note that. Is it an institutional affiliation? Is it a person? So it is important to also take note of that. But accuracy and precision is also an important thing to also take into consideration, because in our profession, citations are very key. Here you can look at two things. You can look at citations and as well as the currents of the information, because credible legal materials typically provide reference to statutes, case law, and similar nature regulations. So when you look at your source, does your source provide citations? But the most important, does it provide the current information? Is it a current position of the law? Is it a current law of that particular jurisdiction or in that particular area? And here, the best example is myself. Back then, for example, when I was working in public service, I went to a meeting. I cited, despite the fact that I was coming from the Attorney General's chambers, I cited a law that has been repealed. It was an internal meeting in preparation for negotiations. So I was easily, informed that there was some amendment that were made. So probably the source of the law where I took my law was outdated. But accuracy and precision is also important. Publisher reputation is important. Lady Justice Mgeyekwa spoke about the LexisNexis. You have the Supreme Court of India. You have the SEC online. You have very credible sources. But then you have these sources that come and go online. So what is your source? You have sources being publishers. You have books that are credible. So publisher reputation, and by publisher here is not a publisher in terms of books, it's publisher in terms of who is publishing, be it online or in whatever environment that you're discussing. But also, as I spoke earlier, we are looking at objectivity and biasness. You also have to be clear and consider sources that provide probably a neutral tone, not necessarily a biased tone of a particular area. So you can also assess the credibility and objectivity by looking at the tone. I mean, somebody is discussing about a particular topic, which you are aware or you have knowledge about that particular area, be it an area of investment, be it social services, be it an area of law or an area of life. Look at the tone coming from the publisher. You can understand whether this one is something that I can rely in assessing the credibility. And I think this one is the person who is leaning towards this particular direction, and therefore probably he is not a good authority in a particular area. But purpose and intent, what is your purpose and intent? You should also consider that, because you can be making reference for purposes of education, or you could be doing it for purposes of commercial. Key, consider here, what would be your source? I mean, you can provide educational materials in commercial transactions and vice versa, and you can't also provide commercial information and materials in an education setup where people are interested in understanding or knowing something. Another area is whether, in terms of purpose and intent, look at also the context. Are you providing legal advice, or are you just providing information to a particular client or to the public? Remember here, we could be discussing about media who are here with us. So sometimes you just intend to provide information. So where do you get simple information that is digested in a manner that you can promote education for purposes of promoting access to justice? But again, another key area is jurisdictional relevance. So look at also jurisdictional relevance in assessing credibility. I mean, you can cite common law authorities in a Roman Dutch scenario, or you can't do the vice versa. Be very adamant about a common, a civil law system in a common law system. So you also have to assess jurisdictional relevance. You also look at clarity and professionalism of a person who is you're relying that material, but you also have to look at cross-referencing. If somebody's paper has been peer-reviewed, or there is an editorial oversight or cross-referencing, that will probably give you a more insight into the credibility of that particular material. So I will move to another area, some other consideration that you have to look at. So you also have to look at the form. I mean, if a material is available on the internet, on the website, for example, look at the manner in which it is published. Is it an HTML? I mean, HTML is just like the way the website looks like. You see, is it a Microsoft Word document? Is it a PDF? Because protection in all these documents is essential. If the document is in Microsoft Word, it means that any person can edit that information. Now, would you prefer to rely on information that is available there in Microsoft Word? I can edit it and upload it again. Probably no. But if it is PDF, is it protected or not protected? You might be aware some of the legislation posted at the website of the Parliament of the United Republic and sometimes at the Attorney General Chamber's office through its online information management system for statutes are protected. You cannot convert it, you cannot copy it. So probably some of those sources could be more reliable by looking at, is the material protected by password or by encryption? Or is it easy to convert? If it is easy to convert, then probably there could be chances that people have tampered with the material. That's also a very important factor to consider. But also key here is the source free? I mean, Madam Justice Mgeyeko was highlighting of the free materials, the paid for materials, the LexisNexis and the Reuters, the Bloomberg. You have so many of them. They provide legal online legal research tools. But I mean, you could consider if it's a free material, then probably you should attach less weight unless it is credible sources such as Tansley and the Legal Information Institutes that are available in most common law jurisdictions in the southern part of Africa. And these have been referred by Madam Justice Mgeyeko, speak of the Tansley ULI, you have the Kenya database, you have the Malawi LI, you have the South African Legal Information Institute, you have the BILI for the United Kingdom, and you have the AUSTLI for Australia. So very important. Again, you have to consider authority here. So you're looking at a piece of legislation, and one typical what we do, you search for the legislation, and then you will click your first link. I mean, is that the authority? So for example, for a law, probably the authority could be a parliament of that particular country. In Tanzania, you could cite the Parliament of the United Republic of Tanzania. You could go to Tanzli because the Tanzli obtains its sources from of laws, for example, from the parliament. So the authority is also very key in ascertaining the credibility. If you're looking for a particular document, is the site or the press where you're looking at that document an authority in that particular area, or an authority to deliver that document? That is very key. Again, can you independently verify that material? I mean, if you can look for another source and make a comparative analysis, that will also be better. But then, as I said, assess the relevance of the subject, assess the relevance of the material in the subject matter. If that document was written in a different context, it's also important to make sure you try to look at materials that are relevant for your topic. When you consider these aspects cumulatively, I think you could be able to at least be credible. And look, the important thing here is that you're providing information, and you're providing information that could promote access to justice and rule of law. So be very careful, or make sure you at least take into consideration some of these aspects so that we continue promoting access to justice and avoid making citations that could not promote the ends of justice and lead to some other consequences that are unintended consequences, so to speak. I will then, my subject, as I said, has two components. It has another component is the evolving legal research landscape. Here, I will look at two components in particular, because there are so much legal trends that are happening in terms of technology and the online legal research tools. But I will pick two and discuss one in detail. I will pick two in the sense that I will look at the influence and the influence of artificial intelligence in online research tools very briefly. And then I will look at also the rise of online legal database, their significance, and the example has been provided by Madam Justice Mgeyeko in her presentation. So we are all aware that, I mean, artificial intelligence is transforming every part of life in ways that we have never imagined before. Large language models, machine learning tools are bringing up massive changes in the way information is being digested and converted. The legal profession has not remained safe. And by safe here, I mean a lot of transformations have happened in the legal field. Today, by using large language models, online research have been transformed drastically through online legal research tools that can provide predictive analytics, customized research platforms. So if you're a family lawyer, you will have customized solutions for family lawyers. If you're interested in investment, you have customized resource for investment and similar areas. But if you can do automated document analysis or automated document comparative analysis. So that is how extensive artificial intelligence has affected what we get from legal research. Today, you can get automated document analysis. You can subscribe to resources that can take a judgment, analyze what has been spoken in the judgment. You can ask that tool to analyze the document within a particular context. I myself use a paid for PDF. The Adobe we are using, Adobe tunayotumia, it can do so. Microsoft Word can do the same thing. It can analyze a document, give you the context in which a document what has been discussed or spoken in the document. It can do case law similarity and difference analysis. So if somebody is citing a particular case law in terms of a particular context, you can cite a particular law, differentiate it. I once worked with a law firm where you have a specialist team that will look at the authorities cited by another lawyer and criticize them. So this is the tool they would practically use. It can do document comparison. It can do contextual analysis, whether a particular authority or document or book or case law is applicable in a particular context, but it can do legal issue identification. What is the legal issue in this document? What is the legal issue in this article? What is the legal issue? What are the legal issues in this particular book? So it's so much that can be done with AI tools today. It can summarize legal documents. It can provide citation analysis if they are proper or they are not, by cross-checking with the authorities and their sources. They can also do legal research, workflow optimization. So they can also look at legal trends. They can also do legal data visualization. And in terms of trends and citations, they will tell you even Tanzli can do that. It can tell you how many citations have been made in this particular judgment, or how many this judgment has been cited. So probably it is an authority in that particular area. So if it is cited over a particular area more than 10 times, it is probably for you, it could be a good law. So they do that quite a lot. They can tell you that I'm a member of a particular platform. They can tell you this case has been cited in this particular area, has been confirmed here, has been expanded here, narrowed here, explained in this judgment. So you can look at which judgment are relevant for your contextual analysis, and then you can do that. That is the extent of what artificial intelligence has done. So you also have online legal databases. These are huge collection of information that are either AI-based or it's just a mobilization. They also provide, they use artificial intelligence, but they are different from AI legal research tools. These are a collection of materials, books, resources, materials, and they provide quick, accessible information to reach the goal of access to justice. They also provide real-time updates and provide collaboration. I'm also a member of a particular platform where it's a legal resource, but it has access to university libraries where you can access books, you can access materials, you can access everything. They also have access and your likes of LexisNexis, your likes of Hain library. So it's a big resources. So they provide legal online research database, provided easy accessibility, real-time updates, and collaborations with platforms that can open your room for extensive legal research. There are also differences in these two particular areas. I think these simple talking notes can be shared. We can look at how this traditional legal research and AI-driven legal research have been transformed and look at the differences. I think this one is, you can get it, and I think I have to wrap up there. Mr. Kaswaga, if you hear me, please take over. Thank you.
Asante sana Mheshimiwa Jaji. Many thanks for your presentation. And let me now welcome. Before that, I'm kindly asking tafadhali waheshimiwa na ndugu washiriki, kama utakuwa na swali weke kwenye chat box, au mwishoni utakapokuwa na wakati wa question and answers utapata nafasi ya ku raise your hand na kuuliza. So far we don't see any questions kwenye chat box. Tafadhali kuwa huru kuandika kwa lugha ambayo utakuwa comfortable kuuliza, kama ni Kiswahili au ni Kiingereza, and I hope facilitators will have time to respond to your questions. So please be free to ask, whether in Swahili or in English. But if you have any question, you have any contribution, I know we have a lot to share, please be free to do so. And someone is asking to number presentation, they will be shared this very evening from us, the Secretariat. Basi naomba niweze kumkaribisha Mheshimiwa Jaji Aisha Sinda, Jaji wa Mahakama Kuu ya Tanzania, kwa ajili ya presentation, the last presentation for today, on challenges and innovations in digital publication, issues of data security, integrity, access disparities, and privacy protection. Karibu sana Mheshimiwa Jaji Sinda for the presentation.
Thank you very much, Honorable Kaswaga. Good afternoon, my lords and distinguished participants. It is really an honor to be among the facilitators on this vital topic of digital publication of decision. My colleagues have discussed the historical background and importance of publishing court decision and the tools available for online legal research. As such, I will focus on the challenges and what needs to be adopted in digital publication and access to justice. I'm particularly interested in personal data protection in the publication of judicial decision. So I will start with the legal framework in relation to personal data protection in Tanzania. And this is the Constitution of the United Republic of Tanzania of 1977, as amended from time to time. And second is the Personal Data Protection Act of 2022. And last is the Chief Justice Circular number 2 of 2018. Basically, the Personal Data Protection Act recognized the right to privacy and personal security as enshrined under Article 16 of the Constitution. And the Personal Data Protection Act sets minimum requirements for the collection and processing of personal data in the United Republic of Tanzania. The Act applies to both public and private institutions with the responsibility to collect and process personal data in Tanzania. As you're aware, the judiciary of Tanzania accumulates significant and sensitive information and will no doubt query whether it is covered by the Act or not. Section 58 of the Data Protection Act exempts the application of the Act if the processing of the data is held in accordance with any law or court order. Therefore, by implication, the Act would not apply to the judiciary. And therefore, the Tanzania Data Protection Authority is restricted from supervising the data processing operations of the courts when they are acting in their judicial capacity. And this is in order to ensure the judiciary's independence in the performance of its judicial tasks, including decision-making. And as Honorable Kifungu said, publication of judgments is a requirement of the constitutional principle of open justice and is a necessary means to support the rule of law. As such, it is in the public interest for the court decisions to be published. As such, personal data processed by the judiciary exercising judicial functions may be published in court orders or judgment. And this is necessary in the public interest of the administration of justice and to enable individuals to understand their rights and obligation, which is an aspect of the rule of law. However, in practice, we have seen a court where it is strictly necessary in the interest of the administration of justice place restriction on personal data, such as an individual name, which is placed in a judgment. The court may also hold legal proceedings in private. And I can give example, in Tanzania, the Chief Justice Circular number 2 of 2018 provide for the protection of identification of children in the adoption proceedings and of victims of sexual offenses of whatever age. But I am not so sure if we do comply to this circular 100%. And the question now is how we can balance public and private interest. Should the judiciary go further and provide guidelines for other areas such as probate, labor, matrimonial, although we have also seen the compliance with circular number 2 is not really up to speed. So also seen in Tanzania the risk of re-identification and profiling arising from the publication of judicial decisions. I have a few examples of practices that can lead to discrimination and public humiliation or violations of the right to be forgotten, which is provided under the Data Protection Act. You have the right, individual right of your information, which is out there in public, in digital public domain, to be forgotten. So we have also observed instances where human resource departments conduct background checks on future potential employees to see if they've had any labor disputes. So this makes it difficult for those with labor cases to be reemployed. And moreover, we have seen also victims of sexual offenses, example, rape, being victimized for multiple attacks that ni tabia yao. You see people say ni tabia yao, hata decision flani ilisema alifanyiwa kitendo hiki. So that is their behavior because they have had similar experiences before. So this is humiliations to the victim, and it is a result of publication of judicial decision. But of importance, we have recently observed some judges taking steps to enhance personal data protection by substituting actual party names with fictional ones in, for instance, matrimonial cases, although there are no specific guidelines for such. So these judges, they've shown that they emphasize the necessity of establishing adequate safeguards to facilitate the successful exercise of individual rights. So next, I'll give an example of some available international guidelines. For instance, the UNESCO has published guidelines for judicial actors on privacy and data protection. These guidelines aim to provide a general framework for judicial actors to assess matters of privacy and data protection in the face of other rights, such as freedom of expression and the right to privacy. The documents include relevant case law from various nations, international and regional bodies that may inform judicial actors' understanding of the matters at hand. It draws a coherent line from privacy rights to data protection rights and the challenges of upholding these rights in the face of new technology. Example, the artificial intelligence, as Honorable Kalunda discussed. And in the UNESCO guidelines, there are some cases which are discussed. And for instance, in LL versus France, it was a family case, and the European Court did hide the identity of the parties, but the European Court also dealt with the challenge of judging a matter that is by its own nature an
Halo, Mheshimiwa Jaji Aisha. Mheshimiwa Sinda, hatukusikii, nafikiri sauti imepotea.
is that they would have declared it inadmissible and still reach the same conclusion, and that the interference was therefore unnecessary and excessive. In conclusion, I observed in some jurisdictions, including Kenya's, parties can request in any case that their identities be hidden. Therefore, I think in Tanzania as well, we can make guidelines governing the publication of judicial decision to cater the challenges that we have discussed on protecting personal information in judicial decision. And this can be expanded from what is already provided in the Chief Justice Circular number 2 of 2018, and it can include other matters, sensitive matters like probate, family and matrimonial cases. This is the end of my presentation, and thank you so much for listening. Thank you, Raymond, and back to you.
Thank you, Mheshimiwa Jaji, for the enlightening presentation and very engaging, very interesting and very insightful. And now, again, as I said, now it's time for question and answers, and I'm asking you all, if you have any question, to put it in the chat box, and we'll read it for our facilitators to respond to. And kama pia utachagua kunyoosha mkono, now the floor is yours. You can raise your hand through an icon on your platform, on the Zoom platform there, so that we can allow you to ask your question, and please be free to do so. For now, I don't see any question on the chat box. Please, if you have any question, be free to use the hands up icon on the chat so that you can ask your question or share your experience. Karibuni sana. And while we are waiting for the question, I see most of ndio, karibu sana Mheshimiwa Jaji.
It's not a question, but I also think we should invite comments, people's views and everything. I note I think I note with appreciation the observations made by one of our members, Mr. Matojo Kosata, in terms of, he's talking about there's a much difference in terms of interface and the usability between the Bailey, the British and Ireland Legal Information Institute, and Tanzili. But again, if you look at, there are also a variety of information and sources in terms of Legal Information Institute globally. You have the AUSTRI for the Austro-Asian countries, you have the Asian countries, you now have the Africa-Lee and different jurisdiction within specific countries. If Mr. Kosato or Matojo, I'm sorry if I'm missing your name, to spell your name correctly. One of the reasons why usability differs in these jurisdictions, and one of the reasons why Africa doesn't have a unified user interface is because we also publish and upload our decision in different formats. Key here is how do you initially upload your information in terms of your local environment, because that then determines the searchability of the document in terms of the interface that you can provide, the manner in which users can access that information. So I think it is important to appreciate that. But I think, as Mr. Kifungu outlined, Tanzili and the technical team are always trying to improve, and I think comments and observations from people like individuals like Mr. Matojo are very key and important. But key here is how do we capture our information in the first place, because that then will determine how that information will allow technology interaction in a manner that can provide certain interface for users to take on. But then you can always consult our Tanzili team in what you want, because part of this session is as well is how part of the objective is how are the users interacting with our online legal research tools, and what is it that Tanzili and the Judicial of Tanzania and all other stakeholders can provide and improve, so that we can always promote access to justice by promoting access to legal materials. Thank you.
Asante sana Mheshimiwa Jaji. Professor Majamba, you have anything to say maybe?
Yes, maybe one comment. I've seen some comments that I consider very useful in terms of ensuring that our presentations are shared with our colleagues, with participants. I just want, by way of rejoinders in terms of adding issues specifically for the local content, so to speak. And I would say three main things. Number one, from our topical issues in terms of publication of court decisions, publication of laws, and then online legal research. Those are the three main components. I would wish to say that history tells us we've come a very long way, and especially with the development in ICT, we need to move very differently. There is no way we can continue solely relying on the old ways of doing things. If all of us remember, there was a time where judges or the court would require copies of judgments obtained from other jurisdictions from counsel because they could not access them. Now things have totally changed. That has moved. The judges are doing a very good job, but there's also a need to change mindsets in terms of ICT development in the context of the existing socio-economic and cultural circumstances. That is critical. Let's not go blindfoldedly. The other area that I would wish to really urge participants, especially counsel, advocates, and other stakeholders, is that we have so many, there is a lot of online information in terms of publication of laws. For example, if you're looking at any international bodies dealing with, maybe you're dealing with a research, or you want to make submissions in terms of treaties, conventions, or any other international legal document, the international legal bodies are credible in terms of what Honorable Kalundu was saying, and Honorable Sinda. Credibility of the international legal bodies, their websites are clear and very, very correct. There's a lot of information across the spectrum in terms of treaties, conventions, even legislation, depending on the topic. The other area that we should keep making reference to are the websites of the National Assembly. For example, the Parliament of the United Republic of Tanzania. They have almost every, in terms of legislation, publication. Quite recent, our colleagues in Zanzibar, or we are also in Zanzibar, not necessarily our colleagues, but Zanzibar also has a very good website where the laws are published both in Kiswahili and English. The Zanzli is also quite active in terms of the case law from Zanzibar. For those of you who may wish to say something about Zanzibar or do some research there. The only challenge in terms of publication of laws, and I think this message should be sent to our colleagues, our collaborators, i.e. the Parliament, but also maybe the respective sector ministries, is in respect of subsidiary legislation. regulations. This is where the nexus of law is. Subsidiary legislation and regulations, these are difficult to find. If you look at most websites of sector ministries, for example, in Tanzania or even in other countries, these are not easily accessible. So we're going back to the old framework where I would look for a colleague, an external examiner from, say, Uganda, Rwanda, Burundi, Sudan, and they'll send it to me, copies, personal copies, but they're not accessible in terms of online legal research. This is critical, and we should not fall in the trap of citing principal legislation, forgetting that most likely there could be subsidiary legislation which we cannot access because they're not online. We need to do further research in that respect. In terms of legal research generally online, I think the presentations have been extremely useful. Words of caution, very loudly made. We've seen a lot, and I should say this very clearly. Some of us, we've gone through some of the judgments of honorable judges, magistrates, and in some cases, Justice of the Court of Appeal, where the reference, you search, and then you find a blog, for example. These are not credible. We must verify whether they are fakes. There are so many publications that are online also that do not reiterate the correct principles of law. We've done some research, and there are cases that we come across, including, and I'll say this with a lot of confidence, including decisions of the Court of Appeal. We've come across that in our meetings, and we have to correct that. So we have to be extremely careful at the use of legal online research. And as elusively clearly pointed out by Honorable Kalunde, that should be it. The other area that I think I should emphasize, and I'm glad we have close to about 100 participants, honorable magistrates, some of the judges, and advocates, counsel. We also prepare submissions in some cases, and there is a danger of falling the trap of being unethical, plagiarism. This is what I have in mind. We've come across submissions, we've come across some judgments. Being chief editor of Tanzania Law Reports, I've read them clearly, and I've pointed out in some places where there's practically, you can tell this judgment or submissions has been plagiarized, and there's no acknowledgement. This is a serious offense, and especially when it's going to be read by people from outside. Shortfalls, and I'll caution here in terms of artificial intelligence, very, very good developments. We should go with that with caution. There are some areas, AI is, or rather even these online searches are fed by individuals, and individuals may feed the wrong information. So it is important to cross-check. I caution that we need to have hard copies. We need to go back to the drawing board. So let's combine a cross-checking reference. We make a mechanism of cross-checking. For example, AI may not easily detect what is not published. For example, customary law of a local community members in a country within East Africa. For example, the Acholi, we have those in Uganda, the Tindiga, the Dinkas. If you ask AI about it, it may give a different interpretation about their customary laws and norms. So let me conclude here for now, unless any other question comes, and I'm still thinking we have enough time. Thank you so much for giving me that time to add on something.
Many thanks, Professor Majamba, for the addition that you have made so far, and it was very, very useful. Now let me welcome Honorable Kim to speak. Unless Justice Mgeko, you have something to add to before I... Yes,
yeah, maybe just add what Professor Majamba have said.
Yes.
Another challenge is in how, I mean, another challenge in regard to online legal research is in regard to same data out or documents outdated. I mean, some legal documents or data are outdated, and some of them are inaccurate. So we need to be really, really cautious on how we select the proper legal research websites. Not every legal research website is useful to us. For example, Tanzli is one of the best, and I've seen somebody, Matojo Kosata, have said it in his message that Tanzli is one of the best legal information institute to depend on. So I just want for others, of other listeners and participants to be aware that there are some legal information institute which are not good for them. That is all.
Asante sana Mheshimiwa Jaji, and let me now welcome Mheshimiwa Kim. Please welcome.
Thank you so much, Honorable Kaswaga, and our presenters and Honorable Judges and Magistrates who are inside here. For me, I don't have anything to say much, but I understand there are so many good comments for Tanzli. We have some challenges, but I think it has been so far a very, very good research place for honorable judges, magistrates, lawyers, advocates, law students, academia, and other professions in their, especially in their research. I think for us, Tanzli, we need to go further, more than what the Tanzli is doing at the moment. The language of the United States Commission on Legal Empowerment of the Poor, it says that law must work for everyone, not just for professionals. And in that regard, we hope very soon with our technical teams and advice from professionals, from board of the law report, honorable magistrate judges and registrars, the international corporations and other leads, we think Tanzli is going to expand its horizon and extend its value to ordinary people of Tanzania, most of whom appear in court without legal representation and with the limited support of legal information in Tanzli. With the advent of rapidly evolving artificial intelligence and machine learning, it is no longer fiction to image, making Tanzania an ordinary people's law library and a self-help hub for unrepresented litigants or any person who wants free legal advice. Because of the artificial intelligence, these learning machine and the ever-growing Tanzli data we should inspire our imagination to move beyond the professionals to empower ordinary citizens to access legal information. So it is time maybe we think about having the artificial intelligence for any person who can just come who can just face the Tanzli, to just open Tanzli and ask Tanzli to say something, and Tanzli can just speak instead of looking on words. You can just maybe open Tanzli and you say, please, naomba nipate hukumu inayohusu labda namna hukumu inavyoandaliwa. And then Tanzli can just speak, hukumu inahusu hukumu inavyoandaliwa, iko hivi na hivi na hivi na hivi, for just an ordinary person to understand how the judgment can just be written. And we think about coming of both languages, Kiswahili and English. So thank you so much for these few words. Back to you, Honorable Kaswaga.
Asante Mheshimiwa Kifungu Mrisho for the contribution. And I think we have questions on the chat box now, and one is a compliment from Honorable Mlanga. We're saying tutazingatia elimu that professor has given us. He's speaking about the plagiarism issues. And we have a question from Honorable Hamza Marishi, who is saying a lot of thanks to all facilitators. Now the question goes to Honorable Judge Kalunde, and it goes as this way. My Lordship, may I seek your clarification regarding the situation where it is established that the online source is not reliable, but the information extracted therefrom seems to be useful to the extent that it may resolve the issue on the table, which could otherwise not be resolved basing on reliable sources. Karibu Mheshimiwa Jaji Kalunde.
Asante. Mr. Kaswaga, and thank you, my co-presenters and all of those who have made comments. I think it is true that sometimes, as Professor also said, there are some blogs that are cited that are not reputable, and probably the information is not reputable, and biasness sometimes. But when I was looking at the assessment of credibility, I spoke about purpose and the intent. Is the information that are available useful for a particular purpose? And objectivity. What is the is the objective that you're looking at, and can you approach that information with some sense of objectivity, regardless of what that source is? For example, if a blog say about say it discusses things that probably you don't consider genuine, but it speaks of a decision of the Constitutional Court or regarding the interpretation of the Tanzanian Constitution. Yes, this is a social media blogger or a joker, but so by connotation, this is a social influencer who doesn't know law, or is just a blogger who blogs about something else, but is talking about a judgment in Tanzania that has been rendered by the court, and that judgment is true and correct. So that information does not become untrue because it is cited by a blogger that is not trustworthy or something. So what is the objectivity? What is the information that has been communicated? And can you independently verify? I spoke about independently verification of the information. I mean, every information that comes from a particular source can be independently verified. If you're speaking about a decision that has been rendered in India about electronic evidence, then you can, if you get the citation of the case, you can always cross-reference, or you can always independently verify from other sources so that you can find the verified information and actually correct information. But then very important for judicial officers is the probative value. Sometimes some of this information, or for lawyers, and whoever is listening. So if you intended to communicate, be it for academic, be it for education, be it for commercial, you have been provided with a particular information. A key consideration is, when we come to court, is probative value. Does it have probative value? Is it objective? Does it make sense? So that is very important sometimes to weigh. But key when you don't trust the source is the objectivity. Is the information objective? But if the information is available on a particular site, if you can query from a different source or from reliable sources, if you go back to search engines, if you go back to research tools and verify that information by looking at how that position of law or how that position of a subject matter is being discussed in trusted sources, then that information becomes correct and valid. So the best way for me, and it happens here, like Professor said, we normally have submissions from councils that cites blogs that they have this information today and they don't have it tomorrow. So again, that is also an issue. Does a blog, would your blog exist today and tomorrow? That is also an issue to consider. But key is relevance and probative value. Relevance, I discussed it in if you want to assess credibility, so you have to assess the relevance. But key here, I said, can you independently verify from other sources that this information can be used, and it can be used, or it expresses the correct position of the law or a true position of the law of a particular industry in a particular jurisdiction. If you can do the independent verification, then that information could be used to solve a problem or resolve a dispute, so to speak. I don't know if that answers the question, but I think at least that is what I can provide. Probably my colleagues can also add, or from the members, also my co-presenters can also add something. Thank you, Mr. Kaswaga.
Thank you very much, my lord. If among the facilitators you would wish to add to what Honorable Kalonda has just responded to the question, Please be free to do so.
I would like to add from what Honorable Kifungu said on majority of the citizens to be able to access judgment on Tanzili through an AI-driven tools. I think this is very important because majority of the people cannot afford traditional legal services. And I think 50% of the population of Tanzania, they have mobile phones and they use internet. It will make access to justice very easy. And I have observed the trend in Tanzania that now we have mobile app like Sheria Kiganjani and Wakili app, which uses the chatbots to connect people in need of legal services with lawyer, and they chat on the chatbots, and some of the disputes are being settled right there on the spot, and these people avoid the necessity of traveling long hours to lodge their cases in courts. So I think the application of AI-powered legal technology can have a profound impact on the legal system. However, as Honorable Karunde said, we have to prioritize on ethical consideration and address potential biases and limitation associated with AI. And I think it will be important if we address these where appropriate by promoting effective regulation so that we have regulations in place like what we have seen in the UE. I mean UE, the European Union. Thank you. That's what I wanted to add in relation to artificial intelligence.
Asante sana Mheshimiwa Jaji. Any other facilitator would like to add to what has already been said?
Sorry, Honorable Kaswaga.
Karibu.
Can I respond to, I don't know, right, Rite, somebody Rite, Honorable Rite, I don't know. The questions, napendekeza maboresho Tanzili. Can I respond to that?
Yeah, sawa, karibu Mheshimiwa.
The response from the question number 1, mashauri yaliyokwisha amuliwa yapandishwe kwa wakati na katika ukamilifu, kwa maana ya kuwa na signature ya jaji, muamuzi na muhuri wa mahakama, maana baadhi yanakuwa yana miss kimoja wapo, hivyo kutiliwa mashaka. Yes, we are trying to scrutinize and try to make the system credible and authenticated. We are removing all decisions and try to request signatures from honorable registrars when it's the judgment of the Court of Appeal. And these are for only judgments which were delivered before the oncoming of electronic case management system. The electronic case management system started last year. It was November, and this problem will never happen again because honorable judges and magistrates are supposed to upload their decisions from the electronic case management system. And it is upon a click of the button for a certain decision to be counted that has been completed. Once it has been clicked and the button is clicked, that decision can always can just drop to the electronic library, and it must be signed, and that's going to be electronic signature. So we are clearing data now, but later on we won't have this problem. And we'll have all decisions in our electronic library, and only decisions from the Court of Records, which is a High Court and the Court of Appeal. These are decisions which can just migrate to Tanzania, and other decisions will be found in the electronic library, which is coming. And there is no electronic library now. It was just, we were developing it for it to go hand in hand with the system of the e-case management, which we have at the moment, and they have the versions for them to interact. So when the electronic library is out, everything will be sorted. But for the number 2 kanuni, secular and amri mbalimbali, ikiwemo za CJ pia viwe na vinapatikana katika mfumo kurahisisha utafiti na utoaji maamuzi. This is very important because we have seculars, case-related seculars and administrative seculars, which are very important. I was a secretary of the team which compiled the compendium of seculars up to 2018, when the late Honorable Dr. Utamwa was the chairman, and Honorable Justin Vanda and the current Honorable JK were members. We have the compilation, which will be updated, and it will just be available for judicial officers. We are working hand in hand with Directorate of Case Management and our IT personnel to make sure that this version is coming in a very, very right way, and then it will just be inserted, and maybe we will have a link in the electronic library. We cannot put a link at the moment in the Tanzania because we think we're supposed to put a link inside the system, which is inside the judiciary. On number 3, nakala laini PDF za law reports za miaka hii ya karibu kuwekwa katika mfumo wa Tanzania kurahisisha not only the miaka hii ya karibu. We need all law reports, including those with no copyrights, especially Tanganyika law reports and High Court Digest and law report of Tanzania, and all law reports, Tanzania law reports, which have been published to be online. And this is once the electronic system, electronic library is validated and is on the system, and it is very soon because the team is at the lab, and we are waiting for the completion of the system for it to be on, and everyone will be will just get advantage, especially all judicial officers will get advantage to view it and retrieve any document from there. Thank you so much.
Asante sana Mheshimiwa Kim for your response. There is a question on the chat box ambayo inasema, why do the laws published on Tanzania differ from those published on other government websites, such as those of the Attorney General and Solicitor General websites? There are noticeable differences in structure and the arrangement of sections. These inconsistencies have created difficulties for law students and lawyers, making it challenging to determine which version of the statutes is accurate. Karibuni waheshimiwa kwa ajili ya response. Possibly I could start with the yes.
Maybe I do that.
Karibu.
Can I proceed to respond? Oh, Professor. Yes.
Yeah, I was about to mention Professor. Karibu, Professor.
Yes, I saw that, and I was going to respond to that. It's a very valid, and because of technicalities of IT, issues like that can happen. But again, as a prudent researcher, you should go back to the drawing board and look for which is the authentic version. Again, that's why I said it's important to make sure that we have backup and cross-checking with the website of Parliament. According to the standing orders of the National Assembly, the Parliament of the National Assembly, the authentic version stays with the clerk of the National Assembly. So the version on the website is usually the authentic version. And because of development, ICT and all that, when you upload a document, there's bound to be issues of format, structure, and everything, but the content is not very different. So that should be a caution, rightly pointed out. And I think it's a very valid argument. We should make sure that we have the right laws in there, because they will be cited to be the authentic. So do not look for laws. That's my caution. Do not rely on laws predominantly on websites of government sectors, sector ministries. Always make a reflection again on Parliament, because they have the versions. Again, that will only be for principal legislation. When it comes to subsidiary legislation, matters could be worse. And I think the stakeholders have had this. I've mentioned that the Attorney General, the Parliament, the Law Reform Commission, in terms of making sure that regulations are also placed and are accessible, because that's where the work operates. Finally, I would want to say something about the version, the user-friendly version for communities who may wish to get an idea on judgments. And I'll take this opportunity to inform participants and some of us who may not have institutional memory. It's not the first time that judgments, in fact, the Court of Appeal, Chief Justice Samata, the case of Dibagula, after pronounced judgments, in that case, the case, Dibagula's case, Yesu ni Mungu, remember that case? In that case, after having written a very lengthy judgment, he summarized that judgment in a very simple document in Kiswahili. Many of you may not be able to access it, but it is there. But the point is that even on Tanzli, it is very possible to go back to the times of the High Court Digest, for example, and then you digest the cases in that line with a caveat that this is a digest. It is not the original judgment, and therefore citizens will be able to access, and therefore have an idea of the judgments that we will be placing on the Tanzli website. Otherwise, thank you. Nashukuru tena. For those of you who are requesting or comments on the plagiarism, I totally encourage you, and most of you are saying you're grateful. But together with plagiarism, I would also encourage counsel in terms of writing submissions, but more so, let me take this opportunity to remind magistrates, judges, and justices of appeal, edit your judgments. We see a lot of challenges. Maybe it's because of the pace, the speediness that you're supposed to reflect them. But once you place a document on public, then the little mistakes that we see, some of them go to the root of the cause. I understand it is rushed, so don't rush to put your signature and upload on Tanzli or counsel when writing submissions. Edit. The editing process should never stop. Thank you.
Thank you, Honorable Kaswaga.
Yes, Mheshimiwa Kim.
Thank you so much.
Karibu. Ulikuwa unataka kuchangia.
Thank you so much for the very, very nice comments and statement from Professor on plagiarism, and that we are supposed to edit. Yeah, he always emphasize, and we are accepting that. Please, let me respond to question from Honorable Kevin Joseph Ndomba. Does it mean that the electronic library will completely replace Tanzli regarding publication of court decisions? Basically, no. The electronic library cannot replace Tanzli, but in the electronic library, we'll have all decisions from from subordinate courts and court of records. And there is currently an exercise of migrating all data, all decisions, to migrate all decisions in the and come back to in the electronic library. And then there will be a window from electronic case management system to electronic library, and then that window is going to be from all court decisions, the subordinate court decisions and the court of record decisions. And then we will allow only court of record decisions to migrate on Tanzli, and court of record decisions are those decisions from the Court of Appeal, High Court, and High Court, all from all divisions we have. So we will have all decisions on Tanzli of the Court of Records and in the electronic library. On Tanzli is for international purpose and the integration. We have the integration between us and African Lee, of which we have so many Lees. And then inside the library, it will be just records for the purpose of protection of our decisions. Once the server of Tanzli is down, we can just still continue with our electronic library. But once the electronic library is down, we can just proceed with the Tanzli. And we understand at the moment, you can even access Tanzli without internet by using Pocket Law. Thank you so much.
Asante sana, honorable facilitators, if you have anything to add before we go to another question from the chat box. Okay, I'm reading from the chat box. Kuna question ambayo inasema, what efforts are being taken to fast track the availability of subordinate court decisions, subsidiary legislations and circulars in public domains, considering that publication of court decisions and legislations is key to access to justice. Karibuni waheshimiwa wawezeshaji wetu.
With your permission,
Can I proceed to the spot? Okay.
Oh, sorry.
Yes, karibu. Naona Professor gonna.
Yes, I wanted to make a clarification.
Yes.
Efforts being taken to fast track the validity of subordinate court decisions. Let me say clearly. Maybe we didn't make it clear. The essence of publication of court decisions is predominantly based on the doctrine of precedent, stare decisis, where we publish decisions of courts of record only, i.e. High Court and the Court of Appeal. Of course, the other courts, High Court and Court of Appeal. So in terms of publishing subordinate decisions of subordinate courts, maybe in terms of making them available for those who want to appeal, but not strictly speaking for purposes of publication, for purpose of law reporting. So that's, I want to make it clear that should be the case. In terms of subsidiary legislation, not legislations, and circulars in the public domain, not all circulars are intended for public domain. Some of them are internal. And I'm sure where it comes to circulars for public domain, that is usually made accessible through the normal channels, public notices, etc. So subordinate subsidiary legislation, that is very critical. Like I said earlier on, it is a challenge not only Tanzania, but in many jurisdictions, and this must be addressed. I've tried to pick it up with the relevant organs, Parliament, and Law Reform Commission. Law Reform Commission. Those are the people that, or rather the authority, the institutions that we should approach and maybe facilitate in terms of even the online and the issue of access to justice. Justice in terms of application of regulations, that is where the law is. Principal legislation, usually framework legislation. The details and the content is usually found in subsidiary legislation. Regulations, if you go lower, bylaws, etc., which affect local communities. So I agree with this, my colleague, Hassan Kasim Mlanga, Mheshimiwa, Senior Raising Magistrate. Thank you.
Asante sana Professor. Mheshimiwa Kim, ulikuwa unataka kuchangia pia. Welcome. Over to you.
Thank you so much, Honorable Kaswaga. There was a question about arbitration and I missed it. Yes, this one. There is a question from Honorable Kevin Joseph Ndomba. It was posted at 1602. The Arbitration Act currently available in Tanzania is unupdated. That it is not the revised one. Okay, we are taking this note and then we'll work on it, and I think we'll just upload the revised one. So that one, the current Arbitration Act or the Old Arbitration Act will just there because of the research purpose. So we can just have all of the two, or both of them. So we upload the act itself, and then we can just even amend. We can just even upload even amendments for research purpose. You might want to make to do research of a certain provision, which was just an old provision of which you want to defer. and then you need to get it no matter you have the revised edition on the system. So we'll work on it and then we'll just give him a feedback.
Asante sana Mheshimiwa Kim.
Mr. Kaswaga.
Karibu Mheshimiwa Jaji.
Thank you. I also join hands with the comments made by Professor Majamba as well as Mr. Kifungu regarding whatever that has been raised by our participants. One thing that is coming out very clearly is that the question of assessing credibility, and the credibility here is not whether a law is credible or not, but sometimes whether the information is updated, seems to appear clearly as something that is very critical. I think we both appreciate that because of the context in which you are working, that as lawyers or working in the legal field, you need to be precise and you need to be accurate in your citations. But again, key of what Professor has raised and what is very essential is authority on the person in which you're citing. Where do you get the right information? But then I also acknowledge that even in Tanzania, there are some pieces of legislation that occur in terms of HTML, where you have a line on your left side of Tanzania where you can click a section and it will appear here, which you don't have in other websites. That is how you interact with a piece of legislation. And again, that is what I said in the beginning. It depends with how you got the information. Kama sheria ilikuwa published kwa namna ambayo hauwezi kuiconvert, hata namna ya kucheza nayo na kuifanya ikawa accessed kwa namna ya kukliki ikatokea itakuwa ngumu. But key here, another message that I think, Prof, you can also take up as well as Kim, because you also help in terms of the judiciary, but Prof, you cut across many areas in terms of both in the academic, but also in terms of policy. I'm aware that the Attorney General has been working tirelessly in coming up with updated versions of revised editions, because even right now, there are some pieces of legislation that it is not even known their number. So they are still being cited as Sheria number 15 ya mwaka 2016 au 17 because they are new laws and they have not been issued with their chapter number in terms of the Law Revision Act. So I think this is something also we can take up as coming out of this workshop, probably because updated versions, the difference between what is appear on the Bunge or Attorney General or ministries of Tanzania, the an updated version of the Arbitration Act, all these speaks of whether we have updated revised editions from where we can track. But again, if we can't have updated versions, but we know every time the parliament sits, there is a miscellaneous amendment that changes the whole complexity of the laws. So still as lawyers, we need to be abreast, we need to be updated with the changes being made. And as Professor said, the correct source is the website of the Parliament of the United Republic of Tanzania, where you can see which laws have been amended by a miscellaneous amendment or by a particular legislation. So we need to keep updated ourselves. We need to update ourselves, but we also need to push collectively as individuals, as organizations, Tanganyika Law Society, the judiciary, members of the academia, and see that we have revised editions from where we can start tracking the transformations and changes in our legislations. So I just wanted to bring up that we also need to push or to assist the relevant institutions in coming up with revised editions, because I think from there we can have some improvement in how we cite our laws and also how we do our researches. Just an input on that aspect. Thank you.
Thank you, Honorable Judge Kalonde. In addition, Justice Kalonde, there's this question, which goes as this: does it mean that the electronic library will completely replace Tanzania regarding publication of court decisions? I would welcome you, Justice Kalonde, if you have a response to that, or Honorable Kifungu.
Okay.
Mr. Kifungu addressed a bit on that and how the interaction will happen between the current case management system and how decisions are being uploaded in the the case management system of the judiciary, how those decisions would go to the judiciary online library, and how the online library will regulate all decisions in the judiciary, as if I gathered correct, in the judiciary online library could be available, but then those who will be published in terms of the stare decisions, as Professor said, will be decisions from the Court of Records. But if somebody wants to do a research, I think Mr. Kifungu would provide a platform where people could access some of these materials from lower courts, if they can be accessed through the Judicial of Tanzania Library, but probably at a particular arrangement, so that the publication, as Professor said, is on the basis of stare decisions, that you publish decisions of courts of record who can make pronouncement in positions in areas of law. So I think Mr. Kim explained that it will not change, but one will feed the other. The Judiciary Electronic Library will feed Tanzli, and therefore whatever that is in Tanzli will be in the Judicial Library, online electronic library, but not all that is within the Judiciary Online Library or Electronic Library will be available in Tanzania, because publication is on the basis of the principle of stare decisis. I think that sums up, if I understood correct.
Asante sana Mheshimiwa Jaji once again. Karibu Mheshimiwa Kim.
Honorable Judge Karunde is very right. With what we are doing, we at the time we are publishing our decisions, we cannot go beyond the international standard. So we have been agreed through the international cooperation that decisions which are supposed to be published on the international forum are decisions from the Court of Records, of which Court of Records we have the High Court and the Court of Appeal. In other countries, there are even Supreme Courts. So for the internal use, we'll just have all decisions from the subordinate courts and decisions from the High Court. But when it comes to Tanzli, which is one of the is listed in the African League, of which these are legal information institutes on at the international level, decisions which will be available there will always be decisions from the Court of Records. And we have the electronic case management system, as I said. We don't have the director of case management here, but when it comes to an availability of court decisions from the electronic case management system, the case can just only be available to parties. And the part is just that person who was registered as one part to the case, and that person can just get that decision from the electronic case management system. And then we say, because of the shared diseases and the issue of the free access to justice, and yesterday at the time we were in the meeting, we had a meeting yesterday, of which Honorable Kiweru Jr. Said one sentence on free access to law, and he said free access is dear to our hearts. Free access is dear to our hearts. And the Chief Justice said we must maintain the sustainability of the free access to law and the court decisions. So, because the electronic case management system will limit availability of court decisions to only parties, we decided that the electronic library system will assist for anybody, because it's a public, it is in the public domain. Any person can just get inside just enter there and access decisions. But when it comes to books and books which are available in library, there will be a borrowing, of which even a person from outside the judiciary, any stakeholder, any person, any party can just borrow, so long as you have your national identity card, you have your ID, you can just borrow anything from the system, and everybody will just register. But we'll only have decisions, we'll just have plenty of decisions from the subordinate courts and from the High Court and the Court of Appeal in there. So it is just, you know, that's why we have several law reports. You can just have a law report of Tanganyika Law Society. You can just have a law report from the registered trustee of the Tanganyika Law Reports. You can just have High Court digest from commercial, from land. It is just to allow accessibility of these court decisions. So in the electronic library, going to be an availability in there. And then on Tanzli, it is going to be an availability as well, but by limits for the internet, for the Court of Records only. In our library is going to be expanded, as I said. So thank you so much for that.
Asanteni sana waheshimiwa for the response to the question. I know we have two, just I think we have one question remaining, and I'm also mindful of the time that we're supposed to be ending. I think this is more of a comment. Edius Deus is saying there are some laws updated in Tanzania which appear to be old, unlike other pieces from other websites in Tanzania. My concern is what should be followed by the general public. I think this was somewhat responded to during our discussions here, but if our facilitators have something to say about it, please, I would like.
Honorable Kaswaga, thank you so much. You cannot outlive all the laws. Because we must have a historical background of what is currently, of what we have currently. So if the decision of the act has been revised in 2022, you cannot avoid to have that act, the same act, which was enacted in 1975. Because there are several amendments inside there of which you're supposed to see the background and why you have these provisions and why we are not there before and what was the intention. So there's no way you can just have only current laws there. So you have the old one, and then if that law has been revised, you upload the revised as well. Thank you.
Thank you very much, Honorable Kim. Now, by way of concluding, I know maybe our facilitators would have something to say as we wind up our discussions today. Let me start by welcoming Justice Ngeyekwa. Honorable Ngeyekwa, if you have anything to conclude before we go to the end of this program today. Karibu sana, your ladyship, if you have anything to say.
I have nothing to add than to thank all participants for their time, and maybe we'll meet maybe next time in the future. Kim will tell us on that.
Asante sana, Mheshimiwa Jaji. Obrigado. Honorable Kalunda, if you have anything to say by way of concluding.
Thank you, Mr. Kaswaga. I also thank the organizers, but I think what is coming out clearly is that the question of assessing the credibility and relevance of online legal materials is coming out very clearly. And I think those who have listed their emails, they can have some of the materials to cross-check, as Mr. Kim said. And a library cannot contain only updated information. We need to have the Land Act or the Mining Act that was enacted in 2020. If it is possible, let's have it. And then we can have 20 land acts of different years, but we should have the revised versions and we should have the amendments. Bringing or bridging the gap of which material is relevant, and I think that is very critical, and that is what is coming out very clearly. And I think going forward, as members of the bar or the bench, researchers, academicians, we should find a way of bringing up the correct information at the right time, but very key to the advocates. Chukua sheria, it is also important kuwa na indexes zilizotolewa zinazoonyesha mabadiliko katika sheria fulani na mabadiliko gani yamefanyika. Very critical, because you cannot say, since I have this law from Tanzania, it is a correct and authentic version. Even the recommendation made by Professor Majamba to go to the website of the Parliament. If you go to an act of legislation that was updated or passed by 2020, 2022, 2023, up to this year, there are a lot of amendments, so it could still not be valid because you also need to track developments. You also need to also have all these miscellaneous amendments because then they will feed into the legislation. With those few remarks, I yield by inviting people to always assess the credibility. Thank you.
Asante sana, Mheshimiwa Jaji, for insisting on credibility. Honorable Aisha Sinda, if you have anything to say before we go to the conclusion, before the ending of
Thank
the
you.
Karibu.
Thank you, Honorable Kasagwa, and my fellow panelists and participants for a lovely and engaging discussion. For me, I've noted what have come out in our discussion is the use of AI in doing our legal research, and AI has changed in the way we carry our personal and work activities. So in my opinion, I think it is important for judges and lawyers to get to scraps on new technologies, and there are so many tools which are available out there, but we have to use them with cautions. Example, Professor Majamba said we should edit our work. Edit, and this is for both judges and advocates out there. There are tools like Grammarly, which edits the work we do, Quillbot, Copilot, Gemini. I think these are all important tools that we can use in legal research, and they can help us to focus more on strategic aspects of our work. Thank you. That's all from my side.
Asante once again, Mheshimiwa Jaji. Karibu sana, Professor Hamoud Majamba, if you have anything to say.
Yes, thank you, Honorable Kaswaga, for the very good moderation. Very impressed.
Asante sana.
And all of you, Honorable Justice Ngeyekwa and Honorable Kalunde, Aisha Sinda, thank you very much, Kifungo. It's been really good reconnecting again. Just words to all of us as participants collectively would be very brief things. Maybe I should take this opportunity to say that step one, Interpretation of Laws Act. You can make the officers of judiciary, including lawyers, can make reference to repealed law, even repealed law, to understand the content of legislation. It's very important. So repealed law should not be thrown away. Finally, ICT is developing. It is creating very many frontiers that have a bearing on access to justice, rule of law, and legal research. We should continue with zeal, a lot of zeal, to follow up these developments and update ourselves through forums like this. And where caution is required, we should exercise that caution in the context of economic, cultural, and political settings pertaining in Tanzania. Asante sana.
Many thanks, Professor Mwalimu wa wengi. Yes, now let me welcome Mheshimiwa Kifungo. Kario Mrisho, if you have something to say before we go to the conclusion of this event.
Honorable Kaswaga, I just thank all facilitators and the guests of honor for their time, and all participants who are in for their comments. I think it's the high time for us.
Mheshimiwa Kifungo, we can't hear you. I think there's an issue with your Mic or connectivity, maybe.
Maybe artificial intelligence.
Artificial intelligence was taking him out.
Each and every
Hello.
time.
Now you've come back. Your worship, you were lost. You're breaking. I think you have an issue with the connectivity. Hello.
It's
Honorable
now off altogether.
Oh, he's gone. Okay. Thank you very much.
Hello.
Yes, Honorable Kifungu. Karibu.
I don't know if you, sorry, I disappeared, but I think it's my request for you to humbly pass greetings to Honorable Justice Kiwelu for what he's doing for us to get knowledge, and for inviting academicians who are very professional, like Professor Majamba, who is mwalimu wa wote, Honorable Said Farunde, Honorable Justice Ngekwa, Honorable Sole. Maybe I cannot follow protocol, but all of them, Honorable Philip, Honorable Aisha, and all participants, and you, thank you so much, and God bless you. I think we can just meet again. Thank you.
Asante sana. Many thanks to our facilitators. We're hoping to have Honorable John Kayoza giving closing remarks. But he said in case he is not able to join, he will delegate to Justice Kalunde. I'm just checking and confirm if Honorable John Kayoza, Judge in charge of the High Court of Tanzania, Manyara, you have been able to join. And if so, I'm welcoming you, my lord. Okay, I think he has been unable, but he informed us of the possibility that he would not be able to join. Now, let me take this opportunity to welcome once again, now as a special speaker for closing this training, Honorable Justice Saidi Kalunde, Judge of the High Court, Iringa Zone, to give the closing remarks on behalf of Honorable Judge John Kayoza, Judge in charge of the High Court, Manyara. Karibu Mheshimiwa Jaji.
Asante sana, Mr. Kaswaga. Like you said, I'm wearing two hats today. Distinguished guests, esteemed trainers, participants, and colleagues and by trainers here, I appreciate the presence of Honorable Lady Justice, Madam Mgeyekwa, Justice of Appeal, for spending and sparing your time. We know your busy schedule because of the arrangements at our Superior Court. And I also appreciate the presence of judges from different registries. I've seen and acknowledged, and I've seen the list of judges present and who have been there from the beginning to the end. I also appreciate senior advocates as well as all advocates who have attended this training from the beginning to the end. You've dedicated your time. It's Friday today. Your Friday starts today. Some of us don't have weekends, but I know you guys have spared your time to be here and present with us. First, I would like to express my gratitude to the Institute of Judicial Administration, IJA, particularly Honorable Kiwelu, for organizing this auspicious and very important training and knowledge sharing experience for the both of us. I also pass my gratitude to the facilitators, organizers, and trainers for their dedication and hard work in making this program a success. To the participants, I applaud your enthusiasm, commitment, and active engagement throughout the training. In today's legal landscape, access to accurately updated legal information is essential not only for the legal professionals, but also for the broader public. The ability to publish court decisions and laws effectively, as well as navigate and conduct online legal research, is an indispensable skill. It enhances transparency, strengthens the rule of law, and empowers informed decision-making. This training has equipped each of us with knowledge and tools to navigate the complex world in legal information dissemination and research in the digital age. We've explored the importance of publishing court decisions and laws in a way that ensures clarity, accessibility, and adherence to the highest standards of legal accuracy. As we have seen, online legal research have revolutionized how legal professionals and public access and interpret the law. The vast repositories of case laws, statutes, and legal literature now available at our fingertips can either be an overwhelming sea of information or a powerful resource, depending on how well one is trained to use it. This training has been vital in shaping our research skills and ensuring that we are adept at the varying credibility of online legal materials. We have also learned the critical importance of relying on authoritative sources, ensuring jurisdictional relevance, and distinguishing between credible information and misinformation. The publication of court decisions plays a fundamental role in maintaining judicial transparency and promoting public trust in the legal system. By making these decisions accessible, we provide not only legal professionals, but the public with a vital tool to understand the precedents that shape our legal landscape. As we move forward, our role in contributing to and supporting this transparency will be inevitable. The skills and knowledge we have acquired and gained today and over the course of this training come with great responsibility. Whatever you are working, be it in the legal field, government institutions, or academia, the proper publication of legal information and the ability to conduct thorough, reliable legal research are key to upholding justice and accountability. Your work will directly impact how laws are understood, how legal precedents are followed, and how justice is perceived by the public. With these tools, you will be able to foster a legal environment that is more inclusive, transparent, and accessible to all. As we conclude, I encourage each and every one of us to continue exploring the vast possibilities of digital legal research, of what legal research offers. Stay curious, remain diligent, and always strive for accuracy and excellency in our work. The future of legal information dissemination is bright, and you are now at the forefront of this critical field. In closing, let me again thank each and every one of you for your active participation. Your hard work over the course of this training has laid a solid foundation for your continued growth and success. I'm confident that the knowledge and skills we have acquired and gained today will serve us well, not only in our esteemed careers, but also in making a meaningful impact in our communities and the public at large. Finally, but not in importance, I thank you all, and I look forward to seeing you, to seeing the remarkable contributions this training will make in our respective roles. Congratulations on the successful completion of this training, and I wish you all the best in your future endeavors. Thank you, and the weekend njema.
Asante.
Asante sana Mheshimiwa Jaji.
Thank you.
Okay, bye everyone.
Thank you, everybody. Bye-bye.
Bye.
Bye.